Hi, my name is Schyler Church. I am a California real estate broker as well as a member of the education department at Accredited Real Estate Schools. We offer those course requirements to be eligible to take the state exam in California, but also we have varying levels of preparation to make sure you're prepared to pass that state test. One of the tools that we use are practice questions. And so we're going to go through a few practice questions today and see how well you're doing with this material. If you like it, make sure to give us a big thumbs up, comment below, subscribe so we keep producing new content. Also, if you like our our material, make sure to check out the link below as it goes over other exam preparation options. Also, if you're wanting access to our entire database of practice questions, you can look at that. But if you're starting brand new and need the courses, we have that on our website as well. So let's get to it and start with the first question. 1. An apartment owner wants to convert an apartment building into condominiums and list them for sale. The apartment owner must comply with the A. Uniform Commercial Code, B. Subdivision Map Act and the Subdivided Lands Law, C. Business and Professions Code, D. All of the above are correct. Well, what we have here is an apartment building wanting to be converted over to condominiums. What that means is they're taking it to where it's one building owner renting out each unit to different tenants, to where they're going to have each unit be owned as a freehold estate and be then possessed by the condominium owner, or they'll rent it out individually. So they're changing the type of ownership to where the units are going to go from all the units being owned by one building owner to then each unit being owned separately. Because of this, this is actually being subdivided. Even though it's an apartment building and to a condominium, it's still being considered a subdividing. And if it's over 5 units, it's called a subdivision. So a condominium can still be considered a subdivision as long as it's over 5 units. Because of that, since they're subdividing it, we know once it's at least 2 units, the Subdivision Map Act applies, where you have to go to the local government officials, so within the city or county that the property is located. But if it's 5 or more, the Subdivided Lands Law also applies, and the Department of Real Estate gets involved because they have to issue, the commissioner will issue a public report. So the best answer, knowing all of this, will be B, Subdivision Map Act and the Subdivided Lands Law. That is the best answer. 2, a township is A, 36-mile square, B, an 18-mile square, C, a 24-mile square, D, a 6-mile square. Well, what is a township? Remember, township falls under that government survey method where we have the intersections of the principal and base lines, and we're going to go through that. And then we use townships that are those squares that spread out. Well, the correct answer here is a 6-mile square. Now, why is it? Let's go through it. So California has 3 principal base and meridian line intersections. So these 3 are Humboldt, Mount Diablo, and San Bernardino. So with these 3, we have these 3 intersections, and we take these intersections. So for instance, right here, we have it to where, let's say this is Humboldt. This is the intersection that we have of the base and meridian line intersections. Well, we then take this and we have squares that go out. So this is called a township. So they go through all sides of this intersection. And these townships are broken down into 36 sections. So a township is 36 square miles or 6 miles square. What that basically means is it's 6 miles on each side. So it'd be a 6 miles, that would do 6 miles square, or you have 36 individual squares within a township. And so that's how we get the 36 square miles versus 6 miles square. And this is a township. Now, a township is broken down into these 36 square miles, and 1 square mile, though, is a section. So 1 section is 1 square mile. There's 36 sections within 1 township. And this all falls under the government survey method that we have of a land description method that we use. So a township is 36 square miles or 6 miles square. If we go back to this, that's why the best answer is 6 miles square. If it was 36 square miles, then that would be correct. But 36 miles square is not correct. That is not correct. A 6 mile square is the correct for a township. But if it was 36 square miles, then that would also be correct. Okay. 3. Usually a broker has a right to a commission only on the basis of negotiations which he completes during the term of the listing agreement, unless A, the listing agreement has a liquidated damages clause, B, he brings a court suit against his principal, C, a protection period clause is contained in the listing agreement, D, the listing involves the exchange of properties. Well, remember, us as an agent are only parties to the agreement in regards to a commission. Well, within this listing agreement that we have stated, it usually has to where if you bring a ready, willing, and able buyer, you are entitled to a commission during the listing period. After the listing period has expired, you are then not privy to a commission, unless there is one where, if you guys have probably heard, where there is a protection period clause. We have it to where it's called a safety clause, a broker protection clause. So there's a bunch of names for it. But what this does is it basically says once the listing has expired, or at that point, the agent has to, or the broker, has to provide a list of names of people they have worked with during the period that may have not actually consummated a sale. But if there is this protection period clause, it says, hey, if it's specified as maybe 90, 180 days after the listing has expired, if anybody from this list purchases the property, I'm entitled to a commission. So it's protecting the broker for a certain period of time to get paid a commission even after the listing has expired. So that is when a broker could be entitled to a commission, is if there was a protection period clause contained in the listing agreement. Not all listing agreements have it, but if they do, that's then where they could get a commission after the term of the listing. Now remember the liquidated damages clause, that deals with if a party breaches the contract, then there's a predetermined amount of damages that are decided, and then brings us a court suit against his principal. So this would be if he's not being paid a commission and due one, then you remember as an agent, the broker, particularly anytime we talk about an agent, we're talking about the broker, they would have to turn to the courts to secure a commission. Then we have the listing involves the exchange of properties. No, remember the commission is determined in the listing agreement, not whether if it's the exchange of properties or what type of sale it is. It has to be determined in the listing agreement. 4. On August 1st, 2021, buyer Abel signed a purchase contract buying seller Baker's home. In the contract, both parties agreed that possession would transfer on September 30th, 2021. Property taxes would be prorated as of possession, not the transfer of title. On November 1st, 2020, seller Baker paid the property taxes for tax year 2020 to 2021. The closing statement would show A, seller Baker paying buyer Abel for 3 months taxes. B, buyer Abel paying seller Baker for 3 months taxes. C, seller Baker and buyer Abel even at the time of possession. D, none of the above. Well, I'll give you a little bit of time to think about this question because this one's a little bit of a thinker. You have to know about how property taxes work, how prorations work. So read this a little bit. If it's easier, pause it and read it and see if you can come up with your own answer. And then I'm going to go through what kind of the train of thought of the correct answer. So what they're saying here is Abel is buying Baker's property. Well, Abel is going to be taking possession on September 30th, 2021. but they stated in the contract that property taxes are actually going to be prorated as of possession, not the date that transfer of title actually had taken place. Usually it would be on the date that title is transferred, but it was decided in the contract that it would be based off of the date of possession. Now, what do we know about property taxes? Well, we have a fiscal tax year that we use. So it's a property tax year of July 1st to June 30th. We do not do a calendar year for property taxes. So, for instance, they're saying here that Seller Baker did pay the property taxes for July 1st of 2020 to June 30th of 2021 on November 1st of 2020. So because of this, we need to then note, hey, yeah, he did pay for it through June 30th of 2021, but we're talking about September 30th of 2021. What is actually going to come about those additional 3 months of property taxes that are owed? Well, the seller actually is going to be needing to pay for those additional 3 months. So it's starting on June 30th, we have then July 31st, August 31st, September 30th. That's additional 3 months. So the seller is going to be entitled to be paying those property taxes. And that would then be prorated in escrow to make sure it's fair. Where Seller Baker is actually going to pay for 3 months of property taxes. And then buyer Abel will only have to pay for the remaining 9 months of property taxes. So they only are, they're going to do who actually owes it, who was owed the property taxes during that period of time. And remember also to further explain this question, it says on November 1st, 2020, Seller Baker paid the property taxes for the tax year of 2020 to 2021. Remember, the first installment is due November 1st and delinquent December 10th. You could pay just for the first installment or you could pay the entire property taxes. So even at this point for the 2021 to 2022 property tax year, the property taxes aren't due until November 1st, 2021. And that's why escrow is going to take into consideration to make sure it is fair for this property tax year. So the best answer out of all of these is Seller Baker paying buyer Abel for 3 months of property taxes to make sure it is fair. 5. If a broker makes a misrepresentation while relying on information furnished by the seller, the broker is entitled to A, full commission, B, no commission, C, a partial commission, D, none of the above. So if a broker makes a misrepresentation, so this could be an actual fraud, this could be negative fraud, so intentional misrepresentation, this could be negligent misrepresentation. Depending on the intent of it, it could be gross misrepresentation. There's a lot of things it could fall under. But if he had misrepresented information because the information was furnished improperly by the seller, so the seller actually is the one that provided the misrepresentation to the broker, and the broker was relying on that information that the seller knew what they were talking about, but they didn't, is the broker still entitled to a commission? Well, usually in a listing agreement, there is a thing called a hold harmless clause. So within a hold harmless clause, the broker is held harmless for misinformation by the seller. So if the seller, or by, the principal, so in this case it's the seller, so the broker would be held harmless because the seller ultimately was the one that did the misrepresentation. So the broker would be entitled to usually a full commission. Now, proving this in a court of law sometimes could be difficult, but based on the theory of law, they would be entitled to a full commission. The actual collection of it, that would be based on in court. So the correct answer would be full commission. Now, what would actually happen if the, let's say the buyer now wants to collect damages for this misrepresentation after the sale of the property has taken place? Well, they're usually going to sue the broker and the seller. So the broker will usually be on the hook as well as the seller, but then the broker could go after the seller to recover their damages that they had to, that they incurred. So remember, it's basically figuring out what is the question particularly asking, and then what is the best answer based on the answer options provided and what the question is asking. So the best answer is A, a full commission.
Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up, as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions, or if you'd like to check us out for completing coursework to be eligible to take the state exam, or even for preparation to help you prepare for the state test, we have tons of options, and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.